On BET News, a debate over what the 1991 Civil Rights Bill covers. Whether the 1991 Civil Rights Bill is retroactive could mean the difference between going to medical school or not for one Chicago man. BET News correspondent Tony Tucker has the story.
In 1991, George Bush signed a Civil Rights Act that puts the burden of alleged discrimination upon the employee. Prior civil rights laws made it easier to prove discrimination. Martin Lewis is a graduate of Johns Hopkins University, who entered Rush Medical College in Chicago in 1983. Lewis claims that his hope of becoming a clinical neurosurgeon was dashed, all because of racial discrimination.
I found out that there were a number of white students with multiple failures who had many more than 2 makeups per quarter. In fact, we take 3 or 4 makeups per quarter or over the summer period. And that was also in violation of the rules. But in my case, the rules were strictly enforced.
Lewis failed several courses, but feels he was discriminated against by not being able to retake certain courses. He filed a lawsuit against the school in 1985 after his dismissal. He contends that a magistrate questioned the fairness of the makeup exams. He also claims that his passing grades were changed to failures by the school's administration. While Lewis's case was pending, the 1991 Civil Rights Act was passed, which Lewis believes should have qualified him for retroactive consideration. The defense won, arguing that retroactivity applies to employees and not students. Now part of Lewis's battle is to change that law. But at the office of the attorney who represented Rush Presbyterian St. Luke Medical Center, he claims, quote, that there was no discrimination involved in the Martin Lewis case.
And the judge who tried his case wrote a long opinion rejecting his claim that he'd been racially discriminated against. That's why he lost his case, because he couldn't prove it, and the judge was convinced to the contrary, that he'd been kicked out for academic reasons and not for racial reasons.
Lewis's brother feels differently.
And by them stealing away his opportunity to become a doctor, it leaves him imprisoned.
It also leaves Lewis fighting for retroactivity. In Chicago, Tony Tucker.
This is BET News with Ed Gordon.
The Supreme Court will decide whether the Civil Rights Act of 1991 should apply to cases that had not been decided when the law went into effect. Congress left the question up in the air in its effort to reach a compromise with the Bush administration. BET News correspondent Sabrina Dames has reaction.
Thousands of cases and millions of dollars are riding on the outcome of the Supreme Court's decision on whether the Civil Rights Act of 1991 is retroactive. 2 cases BET News told you about are among those. Valerie Thomas of Mitchellville, Maryland, is suing the National Football Players Association for racial discrimination. And Martin Lewis of Chicago is suing Rush Medical College in Chicago for the same thing. Both their cases were pending when President Bush signed the 1991 Civil Rights Act into law. Thomas is glad the Supreme Court has decided to settle the issue.
I look forward to it because it's taken a very long time to this point, and I'm optimistic that it will be in our favor.
Lewis doesn't think the justices will rule the law is retroactive. He wants new legislation.
It would be best that Congress act on these cases immediately with legislation, because most of the cases cannot remain in court forever. And it is for the 103rd Congress now to basically pursue retroactive legislation.
Civil rights groups are also waiting for the court's decision. They hope there will be no need for a new law.
It is our view and our judgment, that Congress made and intended the statute to be retroactive, and that it is.
President Clinton, who's still putting his Justice Department together, hasn't said where he stands on the issue. But during his campaign, he wrote a letter to Martin Lewis indicating he thinks pending cases should be covered by the 1991 Civil Rights Act. It will be a while yet before the Supreme Court decides whether the 1991 Civil Rights Act should be retroactive. Arguments will be heard this fall, and a decision is not expected until 1994. In Washington, D.C., Sabrina Dames, BET News.
The reach of a 1991 civil rights law on employment discrimination. The court ruled that the law doesn't apply to thousands of cases that were pending when the law took effect. ABC's law correspondent Tim O'Brien has details.
In Ohio, Maurice Rivers claims he and other black employees were fired in 1986 because of their race.
Because there were 4 black mechanics working at Row Express in the garage there, and they fired all 4 black mechanics.
That same year in Texas, Barbara Landgraf claims she was constantly harassed on the job by a co-worker.
He would grab my breast, my buttocks, put his hands between my legs, rub against me.
Landgraf and Rivers tried to sue their employers under the 1991 Civil Rights Act, even though the alleged misconduct had occurred 5 years earlier. But the Supreme Court said no, that Congress never indicated it wanted the law to apply retroactively, and that doing so might be unfair. The ruling all but dooms thousands of similar suits that had been pending when the 1991 law was passed. It was a long and angry debate in Congress that finally produced the 1991 law, which, unlike previous civil rights laws, authorizes jury trials and large damage awards. Only retiring Justice Harry Blackmun said the law should be applied retroactively, quoting an 1865 precedent that there is no such thing as a vested right to do wrong. Civil rights groups also criticized the decision, saying it clearly allows past racial discrimination and sexual harassment to go unpunished. But there is also a clear message to Congress in the ruling. If you want today's laws applied to yesterday's wrongs, you should say so. Tim O'Brien, ABC News at the Supreme Court.